Oh, I'm sorry.
All rise. The Court of Appeals of the State of Kansas is now in session. The Honorable Angela Coble presiding.
Good afternoon. You can be seated. Thank you. Okay. Get set up here. Welcome to the afternoon session of the October 15th, 2024 Topeka docket for the Kansas Court of Appeals. We have two cases on the docket this afternoon. My name is Angela Coble. I'm one of the newer judges on the court, having been sworn in the spring of 2022. Prior to coming to the bench, I worked as a litigator in private practice and as a research attorney to federal judges. To my right is Judge Catherine Gardner. Judge Gardner worked as a research attorney in both the Kansas Court of Appeals and for the Kansas Federal Court, as an assistant attorney general for the state of Kansas, and also as a litigator in private practice before her appointment to the Court of Appeals in 2015. To my left is Judge Carl Folsom. Judge Folsom is a district judge in Douglas County, sitting today by designation of the chief judge of the Kansas Court of Appeals. Before taking the bench, Judge Folsom worked in the Kansas Appellate Defender's Office in private practice and was also an assistant federal public defender before his appointment to the Douglas County bench in 2022. So the three of us make up the panel hearing the cases this afternoon. So a bit of housekeeping. We're good with technology. Okay. YouTube is going. All right. So we've read your briefs and we've reviewed the record on appeal and we're familiar with the facts of your cases. So just keep that in mind as you're making your arguments this afternoon. As the presiding judge, I'll also act as your timekeeper this afternoon. So if you see me looking or messing with my phone, it's not because I'm distracted. I am using it for timekeeping purposes. So each side will be given 15 minutes of argument. And appellant's counsel, if when we call the case and you announce your appearance, if you could let us know if you'd like to reserve time for rebuttal, we will do that. So after you present your arguments, your case is considered deemed for submission. We'll then take the case under advisement and endeavor to file a written decision as soon as possible. So with that, I'll call our first case. Our first case is an appeal from Shawnee County District Court, case number 127045. Peter J. Ritchie, Appellee versus Billy Joe Lewis, the appellant. So if that case, those members for that case could come forward, please. Okay, and if we could have appearances, please. Who appears on behalf of the appellant, Ms. Lewis?
Bruce Allen Brumley, Your Honor.
Okay, and would you like to reserve time for rebuttal?
Yes, 3 minutes.
Okay. And for the appellee?
Yes, Christine Kaplinger and Brian Smith on behalf of Peter J. Ritchie.
Okay, thank you. Okay, Mr. Brumley, we're ready when you are.
Before I start, can I have a warning?
Yes, when would you like your warning?
I'd like 2 5-minute warnings if possible.
Okay.
And then a warning when my 3 minutes hits. I either blow all the way through it or I leave a bunch of time. I don't know which is going to happen here yet.
Okay.
All right. Good afternoon, Your Honors. I would like to start. First, this is the first time I've been up here since COVID, so it's kind of neat to be back up here instead of doing it by Zoom. I want to start understanding that you've read the briefs. I really don't have anything in addition to the briefs, but I did notice a typo. So embarrassingly, I get to start with that. So on page 16 of the brief, the very top sentence, it was proofed, I promise you that. It says, in relation to the third element, and this is referring to the elements as they relate to unjust enrichment, which is really the only issue we're appealing. And it says the hazmat court required some sort of exception. That word should not be exception, it should be expectation. And if you look at the elements of unjust enrichment, there's 3 of them. A benefit conferred upon the defendant by the plaintiff, an appreciation of the knowledge of the benefit by the defendant, and the acceptance or retention by the defendant of the benefit under circumstances as to make it inequitable for the defendant to retain that benefit without repayment of the issue. Clearly, element 3, which is what we were referring to on page 16, doesn't talk about an exception. It talks about an expectation. And normally, typos are self-explanatory, but this one is pretty relevant because it's really the core of our whole argument up on this appeal. We're arguing that restoration needs to take place to make my client whole. And that really, that's why I accepted this case, frankly, when it was referred to me by another attorney in town. I looked at it and I thought, quite frankly, I thought law school, this is detrimental reliance. Well, I was wrong. It wasn't detrimental reliance, it's unjust enrichment, which I learned in the course of numerous briefs below to Judge Watson is two different things. Now, the first case I cite in my argument talks about restoration. And to understand what we were asking for at trial, it was a very complicated trial. There's numerous issues. The only issue, again, we're appealing is the unjust enrichment finding. You know the basic facts, so I'll just kind of hit to it. There was a purchase of land between a couple that were engaged to be married. Just a recipe for disaster. They fell out of love and everything went haywire. And of course, nothing was put in writing. But there are facts that we believe are pretty, well, they're undisputed from neutral witnesses, such as Mary Frost, who was the real estate agent that sold the land. There's two parcels of land which are relevant. There's a parcel with a house on it and a parcel which was roughly 40 acres of land. My client, she likes to do things, or her kids more so like to do things like riding four-wheelers and using that land. So that land was a big part of the purchase to her. And she approached buying this land. It's some land south of Topeka. Nice set of land, nice house. The house sits on one acreage and there's 40 acres kind of catty-corner off to the side of it. The original purchase price that they actually came to after all the haggling and negotiating, the seller wanted to sell those two parcels for a total of $950,000. My client has the capability to purchase the whole thing, but in the scope of this relationship, I'm going to call him Richie or Mr. Richie. He is present here today, which is great, but below it was filed by Mr. Richie, and then there were counterclaims. It just, to me, it's too confusing to try to figure on plaintiff or defendant. It's Richie and Lewis. Mr. Richie wanted to purchase the property to help out with the sale in some form. Now, again, this happened when the two were together, still planning to be married. My client, Ms. Lewis, agreed to let him purchase the property. There's ample undisputed evidence, uncontroverted evidence. I'm never sure which word to use, but they mean the same thing. In the record that the land was worth roughly $250,000. Mr. Ritchie didn't have $250,000, not a critique, but just the facts. He could come up with $150,000. So my client, Ms. Lewis, agreed he was going to pay $250,000, the $950,000 minus the $250,000 would be $700,000. And then she was going to pay the remaining $700,000 to get both parcels of land. The agreement, and I'm not saying that term in form of an oral contract, which was an issue below. I ain't touching that here on appeal. I'm just here on unjust enrichment because it's meaty. You can see it.
So you're not arguing there was any verbal agreement, an inducement, some promise, anything like that?
Well, I'm saying there's an inducement, but I'm not saying there's a contract. There wasn't a formal agreement. I'm not trying to say that the right of first refusal is created by some oral agreement when, of course, the statute of fraud says it should be in writing. What I'm saying is there's some form of understanding.
But not a promise?
I guess it would depend how you define promise. I'm not saying, I think I'm comfortable saying not a promise. But I do believe there was some form of understanding or inducement. I'm not saying there's a binding contract. I think I do talk about promise in my brief, but I think the first two elements are clear to kind of move forward. I gotta look at my thing.
The
There-
first two elements of unjust enrichment.
Yes, ma'am. There was a benefit conferred to the defendant, which they used defendant, that would be Mr. Ritchie, by the plaintiff, which is Ms. Lewis. That benefit is the $100,000 difference in the transaction. He was able to purchase a $250,000 lot for $150,000. $100,000 benefit was conferred. So I think element one, check mark. I think Mr. Ritchie understood and testified to the same, that there was such an understanding. So it all comes down to what element three means. And I kind of cite heavily that hazmat decision because it seemed to be the best one I could find to define it. You know, it's one of those weird law school issues that we don't see every day. At least I don't have 100 unjust enrichment cases. And they, if you look at page 16 of my brief, they talk about the other party in hazmat was a party called Coastal. That Coastal in some way induced or changed the position of hazmat. Hazmat would be Lewis and Coastal would be Ritchie in this scenario. So in reading that, it doesn't say there has to be a promise. It says it has to be induced. So that's where I came up with the word inducement. That's my own word. That's not in the case. We believe the undisputed facts, there was a relationship. It was very well established that my client wanted to use that land and expected to be able to use it. And of course, like I said, it went south. It probably should have been in writing, but I think that's why the law has unjust enrichment when there's not something in writing, is to fix a situation that isn't fair. When it all fell apart, cutting to it, Mr. Ritchie got a $250,000 lot, which is now worth more, for $150,000.
Counsel, you've got 5.
Thank you.
But how does that disadvantage your client?
Well, let me look at something real fast. My elements again. Well, she lost $100,000, I would think. But
She didn't own the land. She wasn't the person selling the
Oh,
land that
I
was
can
out the
answer.
100,000.
well, okay, if we had just gone straightly by the value of the lands, where if she had purchased it for the 700, and then he'd purchased it for the 250, she increased her part, the house, to 800,000. So she purchased it for another $100,000. Where if he had purchased the land for the full 250, yeah, she would have saved $100,000.
But she was willing to do that at the time because of their romantic relationship, correct?
Well, I would counter to that respectfully, because you're the judge, that she would have purchased the land all by herself. Then she would have the land and I'd be playing golf right now. We wouldn't be here. She would have the land, and now she doesn't have the land, and she conferred unfairly a $100,000 benefit to Mr. Ritchie.
I guess that's what's unfair about that? I mean, they decided to do that. They had a relationship. They were adults. She was a realtor, correct?
Yeah.
So what's unfair about
I don't
it?
like that part of the case either, but it seems unfair to me, Your Honor. I mean, she conferred a $100,000 benefit, expecting a continuation, I would assume, of the relationship, being able to use the land indefinitely. Was it wise? Was it smart? That's not in the elements. She did so. She conferred a benefit. It defies equity. It's not fair. And now, I'm
You're just under 3 minutes. so-
just under 3 minutes.
Mhm.
Can I change that to a 1-minute warning, please?
Sure.
Your Honor.
So if you had to give me 1, 2, or 3 circumstances that would make it inequitable for her to retain this benefit, what would they be?
Okay, you're talking about,
The third factor for unjust
yeah, I
enrichment.
understand that. To retain the benefit, what do you mean by that, Your Honor?
Well, I think that's, for her to, for him to be unjustly enriched.
Uh-huh.
Yeah, for her to be,
I think I can explain how he's unjustly enriched. What are you asking me about my client?
why is it unjust for her not to get the benefit of that $100,000 you're talking about?
You mean, why is it unjust for her to have conferred it to him?
Yeah, for him to retain it.
Oh, well, yeah. She conferred it upon, I think the realtor described it kind of as a hug, on the understanding that she would continue to be able to use the land, have access to the land. I mean, I understand that if she wanted to do that, she should have put it in writing. But again, we have concepts of equity, such as unjust enrichment and detrimental reliance, when the writings fail. And the writings did fail. She had an understanding, they're going to get married, they're going to do all of this. I described this in my brief. I'm not just throwing it in now. She had this understanding that this was going to continue onward. So she gave that 100K, which to me is a lot of money, on that understanding that that was going to continue, and was deprived that.
But he had the same understanding, did he not? You're not alleging he was fraudulently inducing her.
I am not saying it's fraud. I do
Or-
say there was an inducement, but it doesn't rise to the level of fraud.
Right.
Counsel,
Yes, sir.
didn't your client also get, Ms. Lewis, the house and the smaller acreage for $95,000 less than what it was listed for? And then she also got a commission as a buyer's agent for both properties.
Well, yes, the original house price and property price together was like over $1 million. Then I took that more as negotiation. I didn't really see it as relevant. How much time do I have left?
You're out of time, but we're peppering you, so I'm gonna give you some leeway.
All right, thank you. I was concerned. She did negotiate it down, and she did get a buyer's percentage, which I don't remember, agent's percentage, whatever the heck they call it. I don't remember the exact amount of that at all, but she had negotiated it down to $950. And then you have the division of the two parcels, which was, if it was supposed to be 700 and 250, the agent, Mary Frost, and I'm butchering her name, and she's a nice lady, and I apologize, had concerns about that and actually talked to other agents as about it being changed down to 150, with my clients going up to 800. And that's the whole discussion about the hug thing. So I'm more focused, I guess, on that in terms of unjust enrichment. The fact that Ms. Lewis did her job and negotiated a better sale, I would assume benefits everyone but the seller, who's not here today.
But she got a break off. I think the evidence at trial was that a neighbor or something wanted to buy the land for $250,
Yes.
but the sellers only wanted to sell both together.
At some point that happened, yes.
And was there any evidence of anyone else wanting to buy it at $250 at the time of the sale or near that price?
I cannot think of any off the top of my hand, but hand. I'm not aware of any other evidence in that regard. I did have one issue I wanted to hit real quick.
If you could wrap it up.
Yeah, it's, I don't normally respond to the other party's brief, but their last issue, they reference a need to object to the findings of the court. I don't think that really applies here. I went and read their cases, and those cases all applied to criminal cases, which this is not. They applied to like a sentencing, which I've never done. I don't do criminal law. And the findings of facts relating to a sentencing order being inadequate. That doesn't seem to apply here. And they imply that we're asserting fraud as a claim that should be added. We're not, definitely not. All right. Thank you, Judge.
Thank you. I was pretty lenient on time, so I'll give you the same
I don't think
benefit.
I'll take as much time, quite possible.
Okay.
May it please the court. My name is Christine Kapler and I represent the appellee Pete Ritchie in this case. My brief was fairly succinct as to most of my arguments, but I wanted to point out a few things considering oral argument today. As you know, the standard of review that the appellant argue or posted in their brief is the incorrect standard. As you know, this was a bench trial for 3 days, and the court found findings of fact and conclusions of law. And in that case, the court's role today is to determine whether substantial or competent evidence supported those findings of fact, and those findings of fact were sufficient to support its legal conclusions. As to the unjust enrichment claim, the two things I really wanted to note there is the appellant talks about inducement. Inducement is related to fraudulent inducement, and these were discussion points you guys had with opposing counsel here, but it's not an element of unjust enrichment. He claims the hazmat case as cites it, and as he says, cites it very heavily. This is factually distinct because this is actually, hazmat deals with a mechanics lien and a privity of contract between a subcontractor and an owner. So, and it had both a fraudulent inducement claim and a unjust enrichment claim. So that court, as you, I'm sure, are well aware that the inducement was an element to that, but the court did not extend the ruling to anything other than a mechanics lien. Fraudulent inducement wasn't a claim or cause of action towards my client in the district court. That was something they could have asserted and did not. Therefore, that is not in front of the court today. It would be they did not preserve that issue on appeal. Additionally, there's a lot of discussion on detrimental reliance. Detrimental reliance is an element of promissory estoppel. Promissory estoppel was a claim, cause of action against my client in the district court. And not only did the court decide that promissory estoppel should not grant promissory estoppel against Ms. Lewis, but that's not also what they're appealing today. They've made very clear in their briefs and in their oral argument that detrimental or is just unjust enrichment that they're appealing today.
So let me clarify then, because at one point, I think the district court made a credibility ruling in favor of your client, saying that he found him more credible than Ms. Lewis when he was talking about the fact there was no oral agreement about a right of first refusal.
Correct.
And no promise to sell her the land at the same value he got it. Now, those are not really issues that relate now to unjust enrichment, correct?
Correct.
Okay, so was there any other more credibility ruling that the trial court made in favor of either party?
There was some credibility rulings as to a couple of her witnesses, including her mom and her sister. They, in the findings of fact, it was very clear in there that their opinions of my client very much colored their testimony of that day. There was also, she put all three of her children on the stand, which I believe in the findings of fact at the very end. I don't think she was very amused by that. I don't think they were very persuasive in any assistance there. To that point, I do also cite a case that is at the end of my brief. I apologize, I don't have the name. But when there is very minimal evidence of, and I think it had to do with oral agreement or some claim of that in that particular case, is when there's minimal evidence, when the evidence is minimal in quantity, or the evidence is self-serving or something of that nature, it's to be, taken with that grain of salt. And I think that's here in the case. The bigger theory I'm trying to point out to the court is that The findings of fact were the findings of fact. She determined those. It was a 3-day bench trial. She determined that, Judge Watson determined what weight and credibility went to each of the testimony and the evidence. And the interpretation of those facts is one that is for the three of you to decide. But the findings of fact is not something that can be recreated here. An opportunity she could have taken and should have taken is to file for a motion to amend or alter the judgment. KSA 252 or 259 is something that she had the option of doing within 28 days to clarify those rulings. So that way, really what's happening today could have happened in the district court. And not before, to clarify that before coming to utilize these judicial resources.
Are you arguing a lack of preservation?
Yes. Lack of preservation. I think that just based off of both Kansas Supreme Court rule, the local rule that I've cited in the brief, is that they didn't pinpoint where reliance was ever discussed or inducement was ever discussed. They did not, there was no cause of action. They actually were allowed to, since this was second counsel, I believe, second or third counsel, just 4 or 5 months before trial, they were actually allowed to amend their answer and counterclaims, and they chose not to add detrimental reliance or fraudulent inducement. And so they had those choices to make. They didn't, these are all essentially elements of things that we never talked about in trial. It was never in front of the court. So therefore, it should not be presented to you guys today.
But he did argue unjust enrichment.
Yes. Yes, unjust enrichment, that's a topic of discussion, but for it to be, the decision to be changed from what the trial court decided based off of things that don't have anything to do with unjust enrichment is not something in front of the court today. You could take the facts and interpret those into the law, but as long as a reasonable person and could figure out that substantial and competent evidence supported those findings of fact, unless there was findings of fact that supported detrimental reliance or which that's a promissory estoppel issue that he's not appealing today, or inducement. I don't know how that can be an issue other than how it cannot not be an issue of first in front of the court for the first time. If you have any other, I'm going to submit the rest of it on the brief.
I have
Otherwise,
one quick question. The
Sure.
Rule 65 or 165 requirement that to request additional facts, that's not just applicable to criminal cases, right? Your opposing counsel cited a criminal case, but that's a requirement if they're complaining about a lack of facts that applies.
Correct. I could not find anything in my research that had to do with civil cases, but it's a procedural matter. And so therefore, quite frankly, this was a bench case. I know that a lot of criminal cases may or be jury trials, but the procedure is the same in this particular manner, whether criminal or civil.
Thank you.
Any other? Okay, great.
Thank you. Okay,
Do I give my phone?
yeah, we'll give you a couple minutes for rebuttal.
I appreciate the discretion and the time. This was one where I blew through it, it appears. I'm trying to keep this simple. On appeal, we're not arguing fraudulent inducement. We're not arguing detrimental reliance. We're not really, we're applying the law. We decided our standard is a standard of law, which gives unlimited discretion to you three justices. It's the application of those facts that the judge found and didn't, in our opinion, weigh properly under substantial evidence. There was numerous undisputed facts related to this agreement. The first two elements of unjust enrichment are not that hard to see. It's pretty clear. It all comes down to how you interpret that third element. And I guess I've caused a lot of confusion by using the word inducement. I wasn't trying to bring about some fraudulent inducement claim. In the Hazmat case, when they were discussing element 3, they used the word induced. So in my head, I said inducement, and that's what got stuck in my brief. That's why it's there. It's not some attempt to raise a new issue, not at all. Unjust enrichment was a major focal point of that 3-day trial and the testimony. And now I understand why you asked your question. Yeah, the judge found there was no promise or contract, and that is a negative finding. But I don't believe there are any negative findings as to the elements of unjust enrichment. It all comes into that third element as to whether or not there was an expectation and whether or not my client was induced by the overall purchasement, the relationship and the expectations of that relationships, not exceptions, expectations. And then when you look at the very first case in my brief, and I'll sum this up in 20 seconds, it talks about using equity to restore to a fair situation. And I just don't see how that $100,000 conferment giving of a benefit to Mr. Ritchie is fair when and that's why we have equity, Your Honors, and that's why we have unjust enrichment to fix that scenario. Thank you.
Thank you. I'd like to thank both counsel for your arguments. And again, this case is now considered submitted for decision, and we'll endeavor to get a written opinion out in the near future.
Thank you.
Thank you.
Good day.
All right, I'll go ahead and call then our last case on today's docket. This is an appeal from Johnson County. This is case number 127371, City of Westwood, Appellee versus the State of Kansas through the Attorney General and Johnson County District Attorneys in their official capacities. Appellees versus Rebecca Brown, the appellant. Let's have appearances, please, for the appellant Rebecca Brown.
Thank you, Your Honor. May it please the court, my name is Jeff King here with Brian Kriegshauser, appearing on behalf of appellant proposed intervener Rebecca. I may reserve 4 minutes. If you could give me a warning just a minute.
Okay, yeah.
Afternoon, Your Honors. My name is Ryan Dink with McNamee Phillips. I am representing Appellee, City of Westwood, Kansas. With me today is the Mayor of Westwood.
Thank you. Okay. All right, well, we're ready to proceed when you are, counsel.
Thank you, Your Honors. I did fail to mention that my client, Rebecca Brown, is here today along with other residents of Westwood and concerned citizens. Obviously, we'll take the argument, Your Honor, wherever the court wishes to take it. But I want to start out by focusing on what we think are the 4 main points that exist before the court today. 2 of those points relate to Appellant Brown's ability to be before this court today, both in the district court and on appeal. And the other 2 rest on the merits, which I think are 2 independently sufficient grounds, where if the court finds an appellant's favor on either of those, it would be sufficient to overturn the sale and or mandate an election. The first issue is that of standing, and specifically the question of, does Appellant Brown have standing to pursue this litigation from the face of the record, or is it necessary for this court to submit the standing issue back to remand for the district court for its consideration? And in the City of Prairie Village versus Morrison case, where this court considered a very similar issue to this under 12-1301. That court looked at the standing issue and it sort of viewed this issue as a wedge, particularly that when we're looking at particularized injury, which is required, obviously, as one of the 2 points for the court to find standing in this case. In City of Prairie Village, they found standing because the movement in that case was a collector whose name was on the petition. And they found, in addition, that he was, quote, a moving force behind the protest petition, end quote. And in that case, the court also found that a general resident of the city in question would not have sufficiently particularized injury to support standing. So we're really looking from Prairie Village at, is Appellant Brown in the status of a collector or a, quote, moving force behind the protest petition, more so than a mere resident of Westwood?
What if she's not a collector? She's just a signatory. Is she injured differently than the general population?
Given specific, then I think it would go to specific fact findings. The court in City of Prairie Village was clear that the mere act of signing a petition in itself does not constitute standing. But they're also clear that the standing examination, and many other cases have been this way as well, is not one of just looking at one simple fact, but it's looking at the totality of the circumstances as to what constitutes particularized injury. In this case, the appellant was not allowed the ability to put on evidence regarding standing. The district court itself did not make factual findings regarding standing or any finding on standing at all, except to find the proposed intervention moot because the district court had decided the underlying matter. Nonetheless, there are considerable facts in the record that are supportive of standing. We mentioned those in our briefs, but in addition to the attendance of numerous city meetings on this subject, being a face of this movement in the community and getting signatures, both of which were not only acknowledged in the record, but if you look at Appellee's brief at page 40, Appellant Brown's participation was acknowledged even in that brief. In fact, she participated so much in this effort that her former counsel, through her former counsel, was threatened with a lawsuit by the city for tortious interference with a contract based on her actions to oppose. And I'm not here today to say whether that action by the city was correct or incorrect, but it certainly shows that the city thought she was suffered a particularized injury in this matter, more than just a standard resident. Also, there was a recognition by the district court, this is in page 2 of volume 2 of the record, that Appellant Brown appeared to be, quote, an indispensable party that needed to be added to the case. As well on page 224 of volume 4 of the record, the traffic study that is done in this shows that the proposed development would dump about an 80-car parking lot that would exit directly on the street 1 block away from Appellant Brown's home. So we believe there's enough in the record to show that she has been a significant moving force behind the protest petition, that she suffers particularized injury. But if the court disagrees with that assessment, we would respectfully request that the court remand this for consideration by the district court, since full fact-finding was never done on this issue. The second issue that pertains to whether we're properly here before you today as appellant is the right to intervene. Now Kansas law provides for intervention as a requirement, not permissive intervention, but mandatory intervention based upon 3 factors: timely application, substantial interest in the subject matter, and inadequate representation of the appellant's interest. Here, if you find standing, you've already met the substantial interest point. And also timely application is conceded by both sides. So intervention comes down solely to the fact of, were Appellant Brown's interests represented by the defendants in this case? I think the answer is very clearly no. The defendants in this case made an appearance at the first hearing that was literally 3 sentences long, that ended with, quote, "You had a hearing and I'm here." At the second hearing, the defendants said, quote, "We really doesn't have a position on any of these matters." On appeal, the state and the other defendants filed no briefing at all In fact, when this court issued a show cause order, they stated that they had no position on these issues. I think that is pretty much the garden variety definition of not substantially representing the interest of a party. So we believe if you find standing, that by necessity intervention as of right would be required as well. On to the two items that deal with the merits, and we believe either of these, if you rule in the favor of appellant on either of these issues, either of those would be sufficient to undo this transaction. The first one is looking at the protest petition requirements under section 12-1301 as separate and distinct from chapter 25. You may have found it a little bit odd, Your Honors, in looking at our initial brief, that we are not here to claim that the protest petition complies with chapter 25. Quite frankly, it does not. But what we are here and what the district court never considered in its ruling is that KSA 12-1301 imposes separate and distinct requirements from chapter 25 itself. And this was a result that's not only necessary from the statutory language of 12-1301, but was actually envisioned upon the creation of chapter 25-3601. If you look at subsection D of 3601, it specifically states that specific sections in other controlling pieces of legislation supersede the requirements that are set forth in chapter 30 and chapter 25. There is the understanding that there are separate statutory requirements here, one of them being 12-1301. And if you look specifically at the language of 12-1301, it reads, quote, "In the event such a petition is filed with the city clerk within the time prescribed above, no such sale, trade, or exchange shall be made until the governing body shall be instructed to do so by a majority of all votes cast on this proposition at a regular and special election." And within that statutory provision, there are three requirements. Petition has to be filed within 30 days of the notice. If you look at the first volume of the record, page 159, it's clear that that was done. The district court acknowledged it. It was signed by qualified electors of such city equal in number to not less than 10% of the electors who voted at the last preceding regular city election. Page 162 of the record shows that that amount was far exceeded, and that was confirmed by the district court. And then it was, quote, "filed with the city clerk of such city," which is acknowledged by all of the parties here.
Let me back up to that second one about the qualified electors. When it says the term qualified, does that not refer back to the chapter 25 requirements? What you have to say to be a qualified elector?
Respectfully, I don't believe that's the case. I believe that is qualified elector is a term that's defined throughout the Kansas statutes. It is in chapter 25, also used in chapter 12. The definition of qualified elector, my understanding in chapter 25, isn't controlling how that term's used throughout the rest of the statute. We'll certainly relook at that and on response see if I have a different or more nuanced answer, but that's my understanding of how that term is used throughout the statute.
That's helpful. I'm just wondering if these two statutes conflict at all, the 3601 with the 12301,
Because in
1301.
fact, doesn't 3601 say registered? Isn't there a difference, registered elector maybe in 3601 and qualified elector in 1301? I could be,
Rather than trying to do statutory construction by memory.
yeah.
And I don't see that language immediately. Let me look at the break and I'll cover that on response. But on I think the more broad question, Judge Gardner, these are two consistent separate units of statutory construction because 1301 originally was every time you tried to sell a park, you had to have an election. Then the legislature amended that to say, no, every time 10% of the voters in your city are so concerned about the sale of the park that they'll sign a petition and within 30 days, then you have to have an election. And so it was just a more onerous requirement. What was pre-existing automatic, you had to go through that procedure. 3601 concerns a wide application that's used if you're going to contest a bond, if you want to do an initiative procedure and have an ordinance that requires an election. So
Give you a 2-minute warning.
I appreciate it. Thank you, Your Honor. And so here we're looking at for this specific requirements. Let's say that the petition was valid under Chapter 25. That would mandate an election, whether the city decided they wanted to back out of the sale or not. It wouldn't matter. You would mandate an election based on the specific language in that petition. In this instance, what happens under Chapter 12, under 1301, is the city has the option. They choose the language for the election. They could look at this and say, you know what, we thought this was uncontroversial. Over 10% of the electors in our city are worried about it. Maybe we shouldn't go forward with this, and we aren't going to have the sale at all. But if we decide to, we have to do it through election. So these provisions have two separate purposes, which makes sense that they would have then two separate requirements. One with, we believe, the facts on the record show that the requirements of 1301 were met, in which case that we believe the city still has the ability to sell the park. They just have to put it to an election and win the election first. The final point, and I know I have about 30 seconds, we did brief this a lot, is the fact that the notice was insufficient by the city in this case, and was specifically insufficient because the contract they entered into in June of 2023 was not conditioned on the getting through the protest petition and election process. They had, the city at that point in time was bound to the sale of the property and remains bound to the sale of the property. The notice provision in 1301 is specifically designed, uses the word proposal for a reason, because the city wants to sell the property. They go and provide notice. If there's a petition, there's a petition. There's an election, there's an election. And then after that, they can contract for sale and sale. What we've done here is we've actually bound the city by a contract that requires them to perform a duty or pay damages for not performing the duty. And they're trying to give the choice to the citizens of, well, yeah, you can vote on the park now if you do a protest petition, but your choices are sell the park or don't sell the park, and our city could be subject to damages for breach of contract.
So are you saying city has to give notice before they enter into a binding contract to sell?
I'm saying,
At what point?
Your Honor, my point is the city had probably 8 other opt-out provisions for other parties in this contract. The city can simply put in a contract conditional on satisfying its own statutory requirements. Here, they did not give themselves an opt-out for their own statutory requirements. And if you were going to enter into a contract for binding sale, you need to provide notice before that limitation is placed on the citizens. Thank you.
Okay, thank you. Council, I'm going to give you about 17 minutes instead of
Okay.
15, so.
All right, may it please the court. Ryan Dank, again, of McEnany, Van Cleven Phillips on behalf of Appellee. I think where I will start is where the appellant started, which is on the standing issue. Needless to say, we dramatically disagree with their reading of the applicable case law relating to standing. The first place that we start in our briefing relates to the Douglas versus City of Wichita case. That case was actually decided under KSA 12-1301. Appellants, even though we cited that in our motion to dismiss this case, and even though this court directed the appellant to brief standing because it was an issue in the case, they didn't even cite to it in their opening brief. Instead, waiting to violate your all's rule about addressing all matters which are necessary for consideration of the appeal in their opening brief, reserving it for their reply brief. So the Douglas versus City of Wichita case, the Appellee's counsel is correct, did not deal with the right to petition a municipality for to hold an election when selling parkland. Actually, it was more constraining on the municipality. Anytime a city sold parkland, they were required to sell the property. An individual, a citizen in that case, attempted to challenge the sale And the Kansas Supreme Court said under this statute 12-1301, a private citizen does not have legal standing to challenge that transaction. Rather, when you're talking about compliance with these types of laws of the state of Kansas, meaning non-compliance of a municipality with the statute, it is the state, ex rel the attorney general or the district attorney, who is charged with ensuring that municipalities follow the laws of this state.
But that case didn't involve rejection of a protest petition, did it?
It did not, but it's still 12-1301 at the time. Anytime you sell property required an election, and no election was held. And the court in that case said the only party who can overturn the overturn the sale of the city park is the state by coming in and suing. There are other cases that did come down that did specifically deal, and we cite to those in our brief. And specifically, the Appellee's counsel mischaracterizes wholly the Morrison versus City of Prairie Village holding. The Morrison versus City of Prairie Village holding did in fact deal with the protest petition. And in that case, the City of Prairie Village sued. When they brought their action, they sued a circulator of the petition, challenging the legal sufficiency of the petition. The circulator of the petition then came forward and said, no, you have to sue everybody. You have to sue every signator who signed the petition so that you have all necessary and indispensable parties to the action. This court, the Court of Appeals, in that case disagreed. And in the holding, it said, we also fail to perceive how an elector who has signed the protest petition has an interest greater than the interest of any other elector of Prairie Village in the subject matter. As the city argued in its appellate brief, there has been no showing of a concrete, distinct, or particularized injury to be sustained by an elector who signed the petition if he or she were not made a party to the action. So in that case, being a mere signator, which is exactly the status that Ms. Brown holds, she is not a circulator. She was not named in a representative capacity as a circulator of this petition. She is merely an executor of the petition. This court in the Prairie Village case held that a mere signator to the petition holds the very same standing as every other elector in the state of Kansas.
But isn't she in a little different position because she's alleging that the protest petition was rejected unlawfully? Isn't her injury different than just people who don't want it to be used as a park or people who do, when that's a different injury than they suffer?
But that is not the line of cases that we cite to. The Douglas case, the Prairie Village case, the Winelude case. There is an entire line of cases that says merely being a citizen, and we cite to many protest petition cases in our brief, merely being a citizen who objects to the rejection of a protest petition does not give you a distinct particularized injury sufficient to grant you standing. We have one citizen in this case who's looking to overturn, in essence, what the city is doing in trying to sell this parkland. I believe very clearly that all the standing cases dictate that a mere citizen, someone who's merely a taxpayer, does not have legal standing to be in this court and challenge this.
But isn't that because they're just talking about the injury they suffer by virtue of the fact the petition was denied? And here she's arguing the petition was illegally denied.
Well, that would be the truth in every case, right? If you lose and you're appealing it up to the Court of Appeals, I think all the fact patterns on those cases show that you have to be in the district court. In the Morrison case, it was denied at the district court. It was determined to be invalid. That's the same circumstance we're dealing with here.
So let's back up though.
Sure.
So let's assume that Ms. Brown lacks standing. So then where is the injury to the city that gives you standing to file the declaratory judgment action?
Because 25-3601E says any party who believes that there is an invalid form of the question in a petition that they receive.
Well, it actually says it permits a party to challenge a validity determination,
I think that's what I
Right?
said. If I said that.
not invalidity. It says validity.
Validity, right. So we receive a petition and Appellee's counsel is 100% correct. If we receive a valid petition, we're required to hold an election. But the case law in Kansas is also clear that if we don't receive a valid petition, we cannot hold an election. The Appellee's reply brief is incorrect in that. And that all changed when Article 12, Section 5B of the Kansas Constitution was amended under Home Rule that said the only time cities can hold referendums is in those circumstances specifically authorized by statute. And in this case, different than what Appellee is saying, we're saying, and the district court found, that the state petition statute does specifically apply to KSA 12-1301.
But we don't have case law that says that, correct? Is
Not
there
directly-
anything linking those two statutory?
Sure, yeah, we cite to 10 different opinions, the Attorney General opinions. I can give those all to you. Those are, the Reed v. Seaman case is a great example. That in Reed v. Seaman, back in 1999, this court was faced with the exact same challenge that the Appellee is raising here. That they said, well, the statute which authorized a referendum in that case predated KSA 25-3601 et sec, which is the state petition statute. They said because it predated, then the other petition statute, the other referendum statute, which that case turned on, that KSA 25-3601 does not apply to it. And this court specifically rejected that. We cite to 9 other attorney general opinions and cases where that has also been held to be the case. In fact, of the 10 precedents that we cite, every single case found that the state petition statute applies to any time that a referendum is authorized by state statute. This is not an isolated circumstance. Referendums are authorized throughout Kansas statutes on all different types of matters, whether you're going to try and sell bonds, whether you're going to object to a charter ordinance. And every single time that that's been interpreted and applied, the state petition statute 25-3601 and the requirements of that have been applied, and that should also be the case here. In fact, the plaintiff or the appellee in this case is not even trying to argue compliance with 25-3601. The only case that they cite to for authority that they don't have to comply with the state petition statute is the Pretty Prairie case, which was decided by this court. And the protest petition in that case was not a protest petition calling for a referendum. It was a protest petition under state zoning laws, which mandate a supermajority as you go from the planning commission to the governing body, an entirely different circumstance.
Well, they also cite the state statute under the petition laws, subsection D, which says if there's a specific section in other laws, they supersede chapter 25. So what does that mean?
But there's nothing in 25-3601 which is in conflict with 12-1301.
Well, if they don't, but it doesn't require a conflict. It says if there's something more specific in other laws, that supersedes this chapter.
So I guess the question that I would pose is, what does the city put on a ballot? We have a district court ruling that says there's an invalid question on a ballot. What do we as the city put on the ballot? Because state law does prescribe specifically how it's supposed to appear. And state law also says when we get a petition, we have no right to change it. We have no right to correct errors. And that's long-standing authority.
But what does that subsection mean then?
Well,
When would it apply?
I don't know, because every case I found since 253601 has been adopted has applied that statute. The only, again, one case that they find, and it's not a case calling for a referendum, it's a case involving a protest petition on a rezoning matter. So every case that I found in every attorney general opinion that's come down has said, since 253601 has been adopted, that statute applies anytime state statute allows for a petition. So we think that pretty clearly it should apply in this case as well. And really, there's no authority which suggests otherwise.
Does 3601 then just say, well, they got one shot, they didn't get it right, so I guess that's it?
Well, interesting enough, because of the problems that historically, if you look at the legislative history of 3601, because of the problems that petitioners have had formulating an appropriate form of the question, the state put in measures to try and fix that. And specifically, the petitioners are supposed to go to the county councilor to get an opinion as to the validity of the form of the
But
question.
only under 3601, under the more specific statute, right? They just they just file their petition with the city clerk. It's
Well-
with the more specific statute, right?
But KSA 12 or 25-3601 specifically says anytime a petition is authorized by the statutes of the state of Kansas, this section shall apply. It is not, does not allow a variance. And in this circumstance, they didn't comply with that. They didn't take it to the county councilor to get an advisory opinion as to whether or not their petition was legally sufficient. They were supposed to do that. In fact, the city went through that process and checked that box for them. The county councilor said, it is not a valid petition. It is not a valid form of the question. Then when the city is faced with the situation where we're staring at a petition that we think is invalid, we don't think we can put it on a ballot because we don't have the authority to fix it. And so in the face of an invalid petition, the city was really confronted with the situation where we did have to exhaust KSA 25-3601E and seek a determination from the district court that the petition was not valid, which is what we did.
And do you feel like that is statutorily valid? I mean, again, if we're gonna go by 25-3601, it permits a party to challenge a validity determination. Were you challenging a validity determination?
Well, I believe it says 25-3601E, any action challenging the validity of the form of a question in a petition shall be filed in the district court within 20 days after such petition has been filed with the county election officer. So, yes, we filed an action challenging the validity of the form of the question in the petition, and we did so within 20 days of receipt by the county election officer.
And a declaratory judgment is the proper procedural vehicle to do that?
Well, it's a special, the form of the question under 25-3601E is actually a special proceeding. And that is our first argument on appeal, is that 25-3601E doesn't provide a right to appeal from that determination of the district court. And so this court lacks jurisdiction to hear the appeal as to the form of the question, which is count one. The appellee in their brief relies upon some of the other counts in our petition seeking a declaratory judgment to say that that is an incorrect argument. But when you look at the order of the district court at page 5, as to count one, which is the form of the question, the district court specifically relies on 25-3601E. When you look at count one, which is the count that the the district court relied upon at paragraphs 75 and 76, we specifically cite to KSA 75 25-3601E and request a determination as to the validity of the form of the question pursuant to that specific subsection, which is the authority that that court granted. There's a case very similar. It is the TJ Reardon case that came out of Wyandotte County. That was a grand jury petition case, meaning Mr. Reardon was petitioning the court to convene a grand jury in that case pursuant to a petition that had been filed. The district court rejected that, said it was an invalid petition. That statute under the grand jury statute was just like this. Didn't provide a statutory right to appeal that determination. This court in the TJ Reardon case said that's right. There is no Kansas constitutional right to appeal. It's statutory. And in the absence of a statutory right to appeal from the district court's authority to determine the validity of the petition in that case, there is no right to appeal. And this court kicked out that case based upon a lack of jurisdiction created by statute.
Let me ask you a substantive question about the form of the question.
Sure.
Problem, because the district court found that it was not in a proper form. Was that because they said the question is whether the cities shall sell the park rather than shall the city sell the park?
No, I mean, there are numerous deficiencies that the district court identified.
In the form of the question?
Yeah, so in the form of the question, there are still very specific requirements under 3601 and 3602. It shall be phrased as a question. It's required to identify, check yes on the box. It had numerous deficiencies, which doesn't even come close, in my opinion, to satisfying either statute 3601 or 3602.
Council, you've got about 2 minutes.
Okay. So relative to the notice argument that the appellee raised, we obviously contest that. The district court specifically found that sufficient notice was given pursuant to KSA 12-1301. Additionally, the appellee is bouncing all over the place. They can't decide whether we have a contract for sale or whether we've actually consummated the sale. They can't decide whether the statute requires notice before you contemplate a sale or before the sale is actually consummated. In this case, we published notice when we had a contract for sale. That is far from obviously completing a sale. The language of KSA 12-1301 is phrased in terms of we shall not sell it. Well, it's quite frankly a little hard to imagine a situation where a city would post notice before they even know what the terms of a deal might look like. In this case, we negotiated prospective terms. We entered into a contract for sale. That contract for sale had various contingencies. You obviously have to comply with all conditions precedent. We have to deliver clean title, which this legal action has not enabled us to do. That's part of the reason why we had to get an extension of the contract, because this legal action is still pending. And while it's pending, there's a cloud on our title and we cannot sell that parkland.
How do you respond to the argument that even if this is not a consummated sale, it is a contract that exposes the city to liability if the contract isn't performed? It seems to me there's a good reason for notice prior to binding the city to.
Whether that's true or not, and if you do a deep examination of our contract, that's not the way it's consummated. The purchaser's sole remedy is simply to terminate. There are no damages contemplated within it. But even if that's true, that's not what the statute requires. It doesn't require that we not enter into a contract which could expose the city. It says we shall not sell it, and we haven't sold it. And when we published notice, we hadn't sold it. We haven't sold it to this day because of Ms. Brown's challenge. So we've complied with the statute. The district court found as much relative to notice. And I think that that argument, quite frankly, they can't make up their mind when you look at all the conflicting provisions within their briefing as to whether or not we've sold it, whether we just have a contract for sale. They're kind of grasping at straws, in my opinion, on the notices.
Is your position that notice is not necessary until the resolution has been passed?
Say that again?
Is your position that no notice is necessary until a resolution has been passed?
No notice. No, you don't have to publish a resolution to provide notice. Statute
At
doesn't.
what point do you believe the statute requires notice?
What, before sale?
Well, at what point before sale?
Well, but you have to allow the publication of notice and then the exhaustion of the protest petition period before you can sell it. So, we published on November 7th, November 14th. We waited the 30 days. We got a protest petition. We weren't able to sell the property back on December the 3rd of 2023 because of this. Our timeline allowed for all those things to occur before closing. And so, yes, I mean, we satisfied it, and we had mapped it out where we satisfied it before the time that we were to close.
The district court's ruling on the sufficiency of the notice, is that something we have jurisdiction to consider on appeal? Is that a declaratory judgment, or is that still under Chapter 25 in the argument that that's not an issue before us?
Well, I mean, the district court made a factual finding that had been done, and I don't. My understanding in looking at their briefing, they're not disputing that we published what we published on those dates. It's their position that we should have published even before we had a contract, or we alternatively, now they're saying because we had to extend the contract because Ms. Brown's placed a cloud on our title, then now we have to republish, even though the terms of the sale haven't changed. Because she's placed a cloud on our title, we now have to extend our closing. So I don't think there's any factual dispute when we published that we published in our newspaper of record as required by law. And the subject matter of what was published is not in dispute, and the district court found that was sufficient and complied with 12-1301.
Okay.
So
All right.
thank you.
Thank you.
Thank you, Your Honor. I'm glad I reserved 4 minutes instead of 3. Wanted to start with the Morrison case, 2 issues specifically. If you look at the City of Prairie Village v. Morrison case, the argument that council made that this is a non-appealable issue because it's Chapter 25, even though they brought this as a declaratory judgment action under Chapter 60, our proposed petition was an action under Chapter 60. The motion to intervene is appealable as a mandatory motion. If you look at page 3 of the Prairie Village v. Morrison case, this court in that case found this to be appealable, an issue very similar to ours, appealable pursuant to Chapter 60 of the Kansas statutes. If you look at page 3 of that, I think the Morrison case addresses that issue. I appreciated counsel's candor in continually referring to mere citizens not having standing or mere signatories not having standing. That when you look at the Prairie Village case and numerous other cases from this court and the Kansas Supreme Court, the issue isn't, oh, did they sign? Oh, because they signed, oops, no standing. You have to look at the totality of circumstances for particularized injury. We gave you a list of those circumstances that are in the record, even though we didn't have the ability to put out evidence below. I think the Morrison case is very clear that you have to look at the totality of the circumstances impacting the proposed appellant under the conditions set forth in that case. We believe you have enough evidence to do that. If you don't, we believe we're entitled to a remand to have an actual evidentiary hearing on this issue pursuant to the standards outlaid. Turning to Douglas, candidly, I think counsel has Douglas wrong, and wrong in 2 reasons. If you look at what is literally the 4th line of the opinion, it states that Douglas, quote, that was for the purpose of purchasing ground and equipping it for a marketplace, was submitted to the voters of the city in 1929 and that this bond issue carried. There was absolutely an election in Douglas. It says it on the fourth line of the opinion. And if you look at the substantive matter of Douglas, this case was not about the sale of a park. The park had already been sold and transformed in this marketplace. The court itself on page 659 of Douglas defines this action as, quote, "We have reached the conclusion that the end sought in this action is to challenge the right of the city to maintain and operate a wholesale market only as distinguished from one where retail sales would be permitted." The park sale had already happened. It's not surprising that a citizen of the city of Wichita with no particularized injury can't bring a suit against the city to determine whether a sold piece of land can be a farmer's market or a renting space. That's all that Douglas holds. It doesn't hold any of the things that would prevent us from having standing in this case.
1 minute, counsel.
Thanks. The home rule issue was brought up. Home rule was passed in 1959, actually predates Chapter 25, only applies to charter ordinances. So it's our entire point of this, that the home rule provisions they cited here don't apply to 12-1301 used in this way. And, there was a question of contract damages. They threatened to sue my client for tortious interference with the contract, alleging damages that would result. There's clear fear from the city, there's clear recognition from the city in those acts that they are subject to potential contract damages that has placed the citizens looking at this issue in an impossible position.
But isn't it possible they're suffering damages from the fact you've clouded their title and they can't sell it yet, as opposed to later if they simply don't go through with the sale?
And I think that if true actually proves our point, which is they were so late on the notice itself that by applying our rights under 12-1301, that actually clouded their title for its sale that they are legally bound to make. If they provided notice at the proper time, the entire 12-1301 proceeding would have occurred in a way that would not have clouded their title to preclude sale. Your Honor, I would close with the point of we complied with the letter of 12-1301. There's no question to that here. If indeed the law says we complied with 12-1301, but my client has no remedy, what does 12-1301 mean? What is the purpose of this statute? And how can it be used effectively to put the city on notice that they need to have an election as they've had to have for many, many years under the statute in order to sell a public park? Thank you, Your Honors.
Thank you. I'd like to thank counsel for all of your arguments. The case is now submitted for decision, and we'll try to issue a written opinion as soon as we can. With that concludes our docket for today. Thank you all for coming, and the court will stand in recess.